number of instances where it appeared that stored communications, other than those permitted by the Act, were accessed by carriers and provided to agencies. This was not done on request by agencies. As we have no visibility of carriers' actions, we can only recommend that agencies monitor all stored communications provided by carriers and quarantine any stored communications that do not appear to be related to the person listed on the warrant. Noting the number of recommendations made by the Parliamentary Joint Committee on Intelligence and Security regarding industry obligations, any new or reform provisions need to take into account and explicitly note any actions that need to be performed by carriers and internet service providers. Thank you, Chairman.
Thank you very much. Senator Seselja, do you want to get us started?
Yeah, sure. I'm interested in the point you made about a number of instances of carriers providing data. I didn't quite get what you said. Were they providing it outside of the Act? And I think you said that they were providing it not at the request of agencies. Are you able to elaborate on some of those instances you're talking about?
I'll ask my colleague to deal with that question.
From our inspections of the stored communications access regime where this arises, a lot of the requirements of the Act are unclear in terms of specifics, in terms of date of access. So there's a period of 5 days, but the actual definition of the Act raises doubts about what that date actually entails. Now, a lot of the lawful access of a warrant, a lot of that in terms of accessing content is resting with the carriers, and so an agency may do everything in its powers to be compliant, but an action taken by the carrier may lead to something that suggests it was accessed outside the period or the like. So does that provide for the clarification?
Sort of. I mean, how many instances are we talking about? You're saying that there's not a lot of clarity around it. Is it clear that there were a number of instances where it has gone beyond the legislative power?
I'm just looking at the Attorney General Department's annual report for the stored communications. We find it as our assessment criteria at the moment, we're unable to assess compliance for in that entire provision because of the vagueness of the Act. Mm-hmm. So the term access is unsure about the application of that, and we've put that in our reports for the last financial year that we are unable to determine what that date is. And so in your how many instances it would be for every inspection that we did in the financial year last year, we were unable to determine parts of compliance with parts of the Act.
Okay, so maybe you can just explain to me why you're unable to determine compliance with parts of the Act. Mm-hmm. So you're not saying that the Act hasn't been complied with, you just don't know whether it has been complied with in all of those instances. That's
correct. It relates around determining the date of access. Mm-hmm. So I'm just looking at here from what was in the report, in relation to section 108 of the Act, it allows stored communications to be accessed within 5 days after the warrant was issued. And it goes around the date of execution. So the actions of the carriers, what does that mean by execution? Does it mean when they've downloaded that onto a disk and then provided it, or there's doubt about when that actual action, when the warrant was actually executed. And as a consequence, the dates provided, we can provide some caveats. If they're inside the 5 days, it's likely that it was accessed accordingly with the legislation. But if it was, we can comment on things where it's clearly outside. So if it's outside the 5 days, if it's the incorrect number or something like that, we can comment. But as for the actual date of access, that's where the confusion from our end is, and we can't assess compliance with that because of the multiple actions that can be taken that can be considered to be access.
Okay, so the solution, I'm not sure if you touched on this in your opening statement, the solution to that is what? To have clearer wording in the legislation?
I think from our end, a lot of that would be a policy decision, but from our end we see that the stored communications access is the only regime that we look at that has that issue associated with execution not being at the time the warrant is issued.
Yep.
So every other regime we look at and warrant we look at is the execution. It's clear because it's at the time the warrant was signed. In this one, it's an additional action that makes it difficult for us to determine the execution, whether that occurred.
Okay, so if the wording in the legislation was amended to that effect, that would enable you to know whether or not the Act is being complied with?
It would remove any doubt from our end, yes.
Okay, thank you.
Okay.
But for now, I might come back.
All right, thanks. How long, I don't know if calling it a loophole is a bit strong, but how long has that ambiguity been in place in the Act?
Ask you to respond to that, Simon.
We've noted that in our reports, probably for the past 2 financial years, but the issue has been there ever since the wording has come into the Act.
Okay. So you've been unable to kind of execute your responsibilities to a state that you would like for as long as that distinction between stored and stored communications and live intercepts have been in place, which is years and years.
In relation to that particular component of our
piece,
inspection,
yeah,
I think that's fair.
Or might be some value that the committee can play. And when we're talking about, just going back to where Senator Seselja was before, is it a case of too much information being provided by the carrier that, of course, the intercepting agency doesn't know is going to be delivered to them till they open the box, that it might have been outside the terms of the warrant? Is that specifically what you're referring to?
In relation to the stored communication access regime, I think it's not being aware of what's being provided until the carrier's completed their action. Okay. So whatever that product, however that is passed, the agency isn't able to determine that until they receive that. And accordingly, our assessment of compliance is not on the carrier's actions, it's what on agencies do after receiving that information.
Yeah, all right. In terms of public reporting, can I just get clear firstly, the Ombudsman's sort of piece of the puzzle is that you're the ones, as far as the law enforcement community is concerned, you're the ones who have to go back and assess after they've been approved whether warrants were properly executed with the information that was provided was consistent with the warrant. Is that the sum total of your jurisdiction in this area?
Yes.
Okay. And your reporting is entirely into the Attorney-General's office. It doesn't come out to the Parliament after that, does it?
Yes. At the moment, we report only to the Commonwealth Attorney-General on inspection findings. If we were able to report publicly, then that would align with other reporting responsibilities which we have under the Surveillance Devices Act, Part 1AB of the Crimes Act, and other legislative oversight roles. And we also note the Law Council, the New South Wales Ombudsman and the Inspector General of Intelligence have also supported consideration of introducing a public reporting mechanism.
Okay. That's useful, thank you. Given that these are all, well, not all, but many of them are state agencies that are asking for these wiretaps in the first place, do you have any reporting responsibilities through to state attorneys general or state counterparts?
Yes, we do, I think.
Not directly, no. So our reporting is to the Commonwealth Attorney General, but we do, the caveat on that is that we do inspect state agencies that currently inspect state agencies that use the stored communication access provisions of the Act, but we report that to the Commonwealth Attorney General. Okay,
thank you. What visibility do you have of the warrantless aspect of surveillance, which is really kind of zoomed into much larger proportion? I think we're up to about 319,000 warrantless requests for telecommunications data the last financial year. What's your visibility of the paper trail behind those?
We don't currently have any visibility of that.
No.
We have no inspection role in relation to the metadata.
Okay. So, Mr. Neave, did you refer to that in passing on your way through in your opening statement?
Yes, we did. That's one of the changes that we think there should be some involvement of our office in that inspection process as well.
Now, this is a very, very large stack of paperwork.
Yes.
You've made some fairly blunt resourcing proposals in here as well. But how do you propose? Would you propose that you get to read 319,000 of these metadata requests?
Well, I think, as you point out, that would be a significant challenge, resources-wise. I suppose the way in which we would tackle it would be to work out an appropriate sampling program.
Okay.
That would be the normal approach to a volume responsibility along those lines.
Yep.
And then if we form some views, then they would need to be couched in language which said that we had done that which we could in the circumstances with which we are confronted.
All right.
But yet my colleague may wish to add something to that because he's actively involved in the work at the moment.
The only thing I'd add to the sampling size is that we'd have to look at the risks associated with that inspection regime, and it may well be that the most appropriate means would be looking at processes rather than focusing on records per se. So looking at high-level processes in combination with doing a sample may alleviate some of the risks that would occur from not looking at a greater number.
The processes seem reasonably simple at the moment. The agency delegates to a couple of people within itself that it wants information. They get a stamp, then they ring Telstra. So there's not actually much process there. And presumably there's some obligation to maintain or at least report against this act that you did it. Is there any other process that you're aware of?
The only experience that we could call on would be where we look at authorisations and other inspection regimes that we look at, and the Surveillance Devices Act is one of those, where you can look at a number of, I suppose, policies and risk mitigation practices that an agency may have in ensuring that the information provided to that issuing authority is appropriate and that appropriate consideration is given to the facts prior to granting. So that's the only other experience we could have in terms of internal authorisations.
Okay, but still, it's something. This is probably going to sound like it's coming a bit out of left field. What's the current state of thinking, given that you do have visibility of the Surveillance Devices Act as well, about surveillance by drone, or UAV, whatever internal definitions you use, as these things become more and more ubiquitous?
Well, yes, it's a question out of left field. Certainly something that we haven't workshopped internally just yet, but we would see ourselves as a pretty adaptable office who would be prepared to tackle responsibilities
All right.
as long as we have appropriate resources. That's what it boils down to.
Well, the resourcing question, absolutely. Well, consider that I've just flown that and landed it on your desk in front of you, okay. Because that's an area of technology that's changing very, very rapidly.
Yes.
Coming back to where I was heading though, do you have, how much visibility, I guess, do you have, given that it's not part of your formal role at the moment, over the volume of those metadata requests and the fact that they range in spectrum from completely innocuous to extremely invasive? Do you have any advice for us on how to raise the accountability bar, at least on the more invasive end, where you can be making very complete maps of people's lives without judicial oversight?
Yes, well, I suppose what we would argue that the sort of general oversight that we would be able to provide would be, of course, not in the same with the same sort of background as judicial oversight, but I would think that we would be able to develop an appropriate regime which would satisfy as best we could, given the caveats that we would have to refer to, given the volume.
Okay. Thank you very much. I might come back in a moment if there's time. Is there, Marshall?
Sure. Most of the existing oversight regime, including your own, happens after the event. Do you think the whole scheme would be strengthened by having some more rigorous testing prior to the issuing of warrants, such as a public interest monitor?
Well, I think there is a role for our office to perform what could be described as an education role as well. And the setting of frameworks within which organisations operate where they're exercising these sorts of powers would be something that I think we could ourselves contribute to. It's the general approach of the office at the moment is to work appropriately with those who are subject to our jurisdiction in general, whether or not it's in this area of our operations or in our more general complaint handling operations. And I think that that's something that we could sort of consider as part of the role of the Ombudsman. It's different to the way in which you've just expressed it, I know, but it would seem to me that that would be a role that we could play. If we were playing such a role, well then we'd be happy to work in partnership with any other agency which was perhaps established in order to perform a role of setting those frameworks and those guidelines as to how these surveillance regimes need to be operated.
So is there anything stopping you from doing that now?
Well, in fact, I think we do that sort of work already with those who are subject. In fact, I'm sure that we do that sort of work. We have regular meetings not only when we go to inspect records, but between inspections, and we maintain contact with those who are subject to our jurisdiction, and that's something that we see as part of our role.
And what's the level of cooperation that you have from various agencies?
Well, certainly at my level, it's excellent. My colleague who actually goes there and carries out the work might have some other comments to make in response to that question too.
I'd say in general, I'd support that most of the relationships are very cooperative with the agencies we work with, in the sense that the vast majority support best practice to improve compliance.
So can I take it from that there's actually a culture of understanding the privacy issues that are at stake here when they're exercising these powers, or is it simply you're the Ombudsman, we need to keep you happy and make sure you can tick your boxes and get you out of there?
I'd say that is a fair comment, in the sense that a lot of the components of the Act ensure that at least privacy is considered in the application process. So I am aware that the vast majority of agencies have a consideration in the affidavit application process that at the very least turns their mind to the issues of privacy.
All right, thanks, Chair.
Okay. I think that was just about all I had. I don't recall from your submission whether you addressed the question of whether the Act should have an objects clause, or if you've got any other overarching proposals while we're here.
I don't think we referred to an objects clause,
Sure that you did.
Chair.
Okay.
We certainly have no objection to the concept, of course.
Okay. I think all the law enforcement agencies, without exception, have emphasised the importance of privacy as an underpinning of the Act, and we just had, I think it was the Law Council, or one of the earlier witnesses, saying, well, let's put it in the Act then, because it's not there yet. Anyway, unless there's anything else, Senator Sasaljan, you're good? Okay. Unless there's anything else you would like to put to us, we will let you go with thanks.
No, thank you. Thank you.